Go to the Full English Show. We are live every evening, Monday through Friday, on Rumble. Now, before I explain to you everything, what this is actually about, I'm not going to read out the whole judgment. I think there's pages and pages of it, but I will go straight to the conclusions. And I think people need to understand how big this is. So when Pfizer and others were punting out this vaccine, they had a monitoring program in the US, and it was called V-Safe. What I'm going to try and do is explain this to you, and it is really important. V-Safe was like our vase, except it was right at the beginning when they started punting this out, they started pushing it all out. And this is big. This case is massive. Again, it was heard in Amarillo in a district of Texas, and the court has said you must release certain information. Now, I remember when this started happening before, but this is different because the V-Safe had a number of tick boxes, and the tick boxes was if you felt dizzy, tick the box. If you felt slight irritation, tick the box. Do you understand what I'm saying? And these tick boxes were almost minor stuff, just basic stuff. But there was another box there that was called the free text box. And the free text box was where you write in. So you actually write in, I think it was up to 250 characters. So if you had been rushed into hospital and had an heart attack, because it's not on the tick box list, you would have wrote that in there. If you had had a stroke almost immediately, rushed into hospital, you type it into that free text box. If your loved one had just dropped dead of an heart attack, you would type it in there and put it in that little box. Do you understand what I'm saying? The free text box was basically giving people access to say, listen, I've just had this jab and this has happened to me, or this has happened to one of my family. Bang. And all the details and personal details are in there. Why is it important? Because Pfizer and others had basically said that they did not want to release the free text box information. And then it goes into detail. The motion is granted. I'm going to take you straight into that. In response to the COVID-19 pandemic, the United States government spearheaded one of the greatest medical endeavours in history. Within months, Congress allocated billions of dollars to fund, develop, manufacture and distribute hundreds of millions of doses of COVID-19 vaccines. When the first vaccines became available in December 2020, defendants launched a massive safety monitoring program called V-Safe. Because of the rapid and extensive rollout of the vaccine, defendants used V-Safe to quickly collect critical health data for symptoms, adverse events, hospitalisation or treatment, and safety issues directly from those who received the vaccines. V-Safe collected two types of data from millions of Americans. One, the checkbox options, and two, the free text responses. Plaintiffs seek production of approximately, listen to this figure, 7.8 million free text responses pursuant to the Freedom of Information Act, FOIA. Now, in Britain, this would be blocked. Our freedom of information is not worth a toss. Background: COVID vaccines and associated policies. As COVID-19 spread, the federal government collaborated and cooperated with foreign governments and non-governmental humanitarian organisations, in other words, NGOs, private companies, Nazis, and media, Nazis, communist, to enable and incentivise widespread vaccination. Operation Warp Speed, the effort to fast-track COVID-19 vaccines to the American people, removed many of the regulatory and market hurdles for manufacturers while authorising vaccines for emergency use. Just to make sure anyone in America is listening to this and anyone in England, if you know the common law and the ancient laws and customs and usage, you will understand that in English law, and by the way, they've got access to this in Texas because their constitution in Texas is the English common law, you have got something that is called public nuisance. It sounds minor. It's not. It covers this. And guess what the sentence is if you get found guilty? Correct. The death penalty. because it is actually exactly about what they've done here. And no one is talking about this in America. Texas could bring cases against Pfizer and the mainstream media and the government and bring them people into Texas and say, you will face trial for public nuisance under the English common law. And if you are found guilty, you will be executed. Regulatory and market hurdles for manufacturers while authorising vaccines for emergency use. Pursuant to emergency use authorisation, the FDA permitted the use of unapproved medical products and unapproved uses of approved products to diagnose, treat or prevent COVID-19, when we already know that hydroxychloroquine with zinc and ivermectin with zinc, not only was it a prophylaxis, it reduced the length of time COVID could operate, it suppressed it, and it allowed your body to kick in with its immune system and take it out. We're going to go back to, there's lots of information on there, and it tells you in this document everything that you need to know. They tell you how many people were vaccinated. Now, I could talk through the whole thing if you wanted me to, but it may bore some people if I just read it straight out on the screen. So what I'm going to do is just go straight to the core element, the conclusion. This is the judge's order. For the foregoing reasons, and they give all the reasons, plaintiff's motion is granted and the defendant's cross motion is denied. They try to stop it coming out yet again. Additionally, parties are to comply with the following order. This is an order of the court. Defendants are ordered to produce all free text responses together with the registrant number, redacted personal identifying information as described in this order on or before January the 15th, 2025. But listen to what I'm saying to you. This gets better. This is one of the reasons why they've pulled a vaccine injury inquiry and said we're going to hear it next year. Listen, defendants must produce batches of free text responses on a first-in, first-out basis. So as they first started to jab people up, people started to drop, people typing stuff in the free text boxes, not in the tick box, all carefully designed, and they thought they could keep this out of the public eye. Defendants are ordered to comply with the below-listed minimum production schedule. So they're not saying you can produce this in 2025. They have to do it now, but it's scheduled. Defendants can bank any processed free text responses it reviews and redacts in excess of its monthly quota. In other words, what they're saying is, if you give us a year's worth now, and then you have a lull of a year, but your quota is still within that figure, that's called banking. Parties are ordered to work together in good faith in the production process. Concerns regarding production, redaction or deadlines should be promptly presented to the court by a joint filing after parties have attempted to resolve the issue. On the 1st of April, July, October and January, the parties are ordered to submit a joint status report regarding rate and quality of production or any other matter that arises. So they got to report back to the court what they've done. The first lot, listen, February the 15th, 2024. The minimum that they're allowed to produce, the minimum is 390,000 of that free box information. So 390,000 adverse serious effects that you've never seen before are going to be released on the February the 15th, 2024. And then March the 15th, 2024, they've got to put out another 390,000. April the 15th. And then April the 15th, they've got to come to the court and everyone's going to look at it and say, is this exactly what you want? Yeah, right. Then we'll hear more of it. So it goes back to them. Everything's been set out in a schedule, even the recurring court dates. And on May the 15th, 2024, 650,000 must be released. On June the 15th, 2024, 650,000 must be released. This is the cumulative minimum. So by June the 15th of this year, 2.5 million free text results of adverse effects. So people could be writing in there myocarditis, could be writing in there brain hemorrhage, could be writing in there my eyes popped out. Anything that was Everything that you can think of is going to be in them boxes, and they're going to be using AI to sort through every single one of them. Just think about this. July the 15th, 650,000. August the 15th, 780,000. September, 780,000. By January the 15th, 2025, the last 780,000, which makes 7,800,000 previously held as secret and confidential, must be released for public information under the Freedom of Information Act in the United States of America. Can you see how big this is? Just make sure you all are aware this is the court order, so ordered, and it was released today because I've seen the order today, January the 5th, 2024, Matthew J. Kaczmarek, United States District Judge. And there he is signing his order, and there's the information. There's the schedule. Do you understand how big this is? So you're now going to get the information. So you imagine a statistician and other people and other doctors, all them doctors that stood up and told you the truth, the whole truth and nothing but the truth, and that was pushed to the side. There's no evidence of that. There's no evidence of that. And the mainstream media saying there's no evidence of that. All them fact checkers pushing this out and making you and your families go and have that jab. They're releasing the information. So in that 3-box text, if you typed in there myocarditis or my 7-year-old son's just died from the jab, it's all going to be in there. Everything. Strokes, blood clots, passed out of the wheel and crashed just after it, had a heart attack. I spoke to someone today and they said their ex had the jab. And 10 minutes after she had the jab, she had a heart attack. In the actual clinic. They actually come up to her and said, "You feeling all right?" She went, "No." And then she went, bang, she had a heart attack. All of that information is going to be in that little box. Did anyone know that this order has been signed and 7.8 million of this information is coming out? And again, where's it come from? Texas. When this is released and the attorneys start using it, heads will roll. Now, can you understand why they need a way of covering all this up? It's the only thing big enough to cover any of this stuff up is a war. And I'm talking about a nuclear war, and I'm talking about it escalating. Now, all of a sudden, they've all gone the right way into that court. That court, the International Court of Justice, is important to stop it triggering. Now, these judges are going to look at this in that court and think, saying, we could stop a war here, but this information's coming out. This information is coming out. What happened to our yellow card information? Steve Lomas, I make you absolutely right. What happened to our yellow card information? The major point of this, all of these doctors that was telling you, signing the declaration, do you remember that declaration? Someone's going to tell me what it was called in a minute. Remember that declaration? There was 10,000 or 20,000 doctors that tried. Doctors getting sacked if they said anything. Nurses that was understanding and looking and thinking, listen, this ain't right. And they carried on. They've carried on. And if they carried on knowingly, and you're talking about people now that are sterile, it's obvious, isn't it? It's obvious what the agenda was. And then they thought to themselves, we'll have a war and all. The point I'm trying to make to you here, have you heard about this on Sky News, the BBC, and I don't watch it, so it may have been on there. Have you heard about it on GB News? Have you heard about it anywhere? Has anyone told you about this? We're being suppressed and oppressed by the British. So America's defendants have consistently asserted that COVID-19 vaccines are safe and effective, recommends everyone aged 6 months and older get an updated COVID-19 vaccine, and added the COVID-19 vaccine to standard child and adolescent immunisation schedule. The V-Safe programme, contemporaneous with the rollout, defendants launched the V-Safe programme, the defendants did, to monitor vaccine safety in real time. V-Safe employs a smartphone-based application allowing participants to voluntarily enrol and report their or dependents' health after vaccination, ECF number 29 at 1213. V-Safe collects basic personal information, e.g. name, mobile number, date of birth, sex, zip code, and the vaccine doses he or she has received. Can you see how much danger? Let me tell you something. This is absolutely ripped of a new one. It's all going to come out. To preserve confidentiality, each participant is assigned a registrant code permitting analysis to connect the participant's various surveys without compromising his or her identity. The application sends text messages to the participant with individualized links to the web-based health check in surveys, ID. The surveys are administered one daily for 7 days, weekly for 5 weeks. Imagine this, 3, 6 and 12-month intervals. Imagine all of that linked into this. This schedule repeats with each subsequent dose or booster. So every time it starts again. Questions include 10 pre-specified CTB answer choices for symptom check. Listen to this. This is the symptom check. This is the check boxes. Chills, headache and nausea, and health impact relating to the ability to work, perform normal activities, treatment or hospitalisation. The check the box data was released pursuant to the separate FIOIA litigation. See informed consent section, Network versus Centres for Disease and Control and Prevention, civil action, blah, 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 right? So they'd released the first lot of information, but they wouldn't release the free text. Each survey also includes optional free text fields for any other symptoms or health conditions you want to report. And please describe regarding healthcare treatment or hospital visits. There are approximately 7.8 million responses, limited to 250 characters in length. These FTRs are the subject of the present litigation. Plaintiff alleges the bifurcated data collection method was designed to restrict reports of adverse events to the free text entries, suppress the number of reported adverse events, and render that data difficult to standardise, and thus create a misleading health and safety profile of COVID-19 vaccine that is safe and effective. Notably, vSafe is not synonymous with other reporting systems maintained by the defendants, including the Vaccine Adverse Event Reporting System, VARS. VARS detects and characterises rare and unexpected conditions, while vSafe captures common and even expected symptoms in a checkbox responses and any other symptoms in the free text fields. While VARS data is processed and made publicly available, none of the vSafe data is included in the VARS disclosure. Additionally, defendants are in the process of converting all free text responses to standardized medical code and have released some 5 million converted entries. Thus, release of the vSafe free response data is requested is separate from the check the box and standard VARS disclosures. Plaintiffs for the Freedom of Information request. While trust the science became something of a national slogan, the American public's trust in science and scientists are an all-time low. It is with this background that plaintiff aims to further the ideals pledged by the Biden-Harris administration to promote trust, transparency, common purpose, and accountability in our government. Common purpose. By making available for public access, and particularly for independent scientific and medical research, all of the relevant health data collected through the vSafe program, as the check the box data has already been released, it is the free text response data plaintiff seeks. Plaintiff is a non-profit that exists for the sole purpose of obtaining and disseminating to the public the data from the free text fields in the CDC's vSafe database. The group is comprised of medical professionals, including practitioners, researchers, and educators. The non-profit is a registered Texas domestic non-profit corporation with its sole headquarters and principal place of business in Amarillo, Texas. Yes, that's where our phone number is for the call-in. Plaintiff maintains a website with doctorforchoice.org intended to facilitate publication of the free text data in anticipation of production pursuant to the Freedom of Information request or court order. On January the 3rd, 2023, plaintiff submitted a Freedom of Information request with defendants pursuant to the blah, blah, blah. Plaintiff request description was all data obtained from vSafe users' registrants from the free text fields within the vSafe program for COVID-19 vaccines and the registrant code associated with each free text field entry. That means, so when someone's got an ID associated with them, and they've got and they go back on it and they say, I've got another one, and then go and have another jab, and it all starts again. That ID is associated with them, so it will follow them through their vaccination process. Further, plaintiff acknowledged that redaction may be necessary and therefore requested defendants segregate and disclose the non-exempt portions. Plaintiff also requested expedited processing and waiver of associated fees. The CDC immediately denied expedited processing. This is the CDC that it's against, right? And waiver of fees, and asserted the unusual circumstances warranted it and an extension of time to respond to the request. Thereafter, defendants issued a final determination to withhold all of the free text responses. They're trying to do this because the Biden regime carried on with this program knowing that people were being injured. And I just want you to understand something here. The COVID inquiry in that British Parliament, which is all bullshit, they've now pushed away all the vaccine injury stuff until after the election. I don't think there's going to be an election. Information like names, birth dates, social security numbers, and defendants' lack of resources. So again, all of this information is in there. Legal standard, modified summary judgment standard in the context, and it goes into more and more information. I could go through all that stuff, but I think that would bore you all to tears. What do you think of that?